Australia is known for its intricate and dynamic immigration laws, which are designed to strike a balance between regional development and economic expansion. The Australian government made a number of significant modifications to visa categories in 2024 in response to the continued need to address regional development, demographic concerns, and skill shortages. This video outlines 8 important visa changes in 2024 across skilled migration, temporary work, and student visas, and what they mean for prospective migrants in the future. 1. Skilled migration visa reforms. A key component of Australia's immigration policy, the Skilled Migration Program saw considerable changes in 2024 with the goal of attracting individuals with in-demand skills and promoting economic expansion in Australia. This method simplifies the application process for both businesses and candidates by combining pertinent jobs into a single list that is targeted at industries with severe shortages, such as healthcare, technology, and construction. 2. Changes to the PR points-based system. Exploring a revised point system to more accurately identify immigrants who would propel Australia's long-term growth is one of the main areas of future reform specified in the migration strategy. Applicants in fields including healthcare, engineering, and IT that are thought to be essential to Australia's long-term development will now receive extra points. Additionally, candidates with advanced English language proficiency, those under 45, and those with years of work experience in their sector will receive bonus points. 3. Emphasis on regional migration. The skilled migration strategy includes encouraging regional development in large part, and the goal of the modifications to the regional employer, sponsored visa subclass 494, and the skilled work regional provisional visa subclass 491 is to incentivize immigrants to settle in regional areas. In order to promote long-term regional settlement, migrants in regional Australia who are employed and remain there under these visas will now have an expedited route to permanent residency. 4. Visas 482, 494, and 457 changes. Conditions 8107, 8607, and 8608 are changing. When a sponsored worker with these visas ends their employment, they will have an extended period of time to look for a new sponsor, reapply for a different visa, or make plans to depart Australia. Workers get 180 days at a time, or a maximum of 365 days during the course of the visa period, in place of 60 days. Furthermore, they are free to work for other companies without a nomination that has been authorized while they look for a new sponsor. 5. Visa policy changes to TSS visa. A noteworthy modification to the 482 visa pertains to the reduction of the work experience prerequisite for acquiring the 482 visa, which is anticipated to come into force in late 2024, subject to legislative approval. The requirement that work experience be obtained within the past 5 years has been removed, which is a big improvement. Consequently, candidates are now able to consider a wider range of experiences, including ones from early in their professional lives. 6. Employer-sponsored migration changes. Employers now find it simpler to sponsor qualified migrants in vital areas because to revisions made by the Australian government to the employer-sponsored migration pathways. Employers can now sponsor employees for permanent residency under the employer-nominated scheme subclass 186 visa, which has undergone revisions to streamline and expedite the application procedure. Companies in sectors like healthcare and construction that are experiencing severe shortages gain from expedited visa and nomination procedures. 7. Changes to onshore student visa applications. Certain visa holders, such as those with visit and temporary graduate visas, will no longer be eligible to apply for student visas while in Australia. This action is a reaction to the practice of permanent temporariness in which people apply for repeated visas in an attempt to extend their stay even though they may not be eligible for permanent residency. 8. Introduction of workplace justice visa. For all temporary immigrants claiming to have been the victim of labor exploitation, the Australian government has instituted a special visa known as the Temporary Activity Visa. A 2-year initiative called the Workplace Justice Pilot is intended to support temporary employees who feel they have been taken advantage of by their employers. If reporting workplace exploitation would benefit from your stay, you may do so for up to 6 months. And if reporting workplace exploitation allegations is required, and it is in the public interest, you may stay for up to 12 months. That will be all in this video. Please share your opinions with us in the comments area. Don't forget to like, subscribe, and enable the notification bell to receive updates on job and immigration news. Thanks for watching.